because I have notes on this. And I think it's
Ready? Good afternoon. Before we begin, I'd like to ask those of you who are lined up along the walls over here on the side and across the back over there, if you'll come in and move in closer in the center with these folks and share a seat with them, it'll be more comfortable for you. I know that it's awfully crowded here this afternoon, and we just want to make sure that, excuse me, you're laughing at me. Good afternoon. My name is Joe Groman, and the property professor in me really wants to introduce these gentlemen as R1 and R2, but I'll let them go ahead and introduce themselves.
My name's Ron Eads. I'm a faculty member from the law school at the University of Louisville, and I teach torts and evidence primarily.
And I'm Ron Brown. I teach at Nova Southeastern University with Joe Groman, and I'm also a property and contracts teacher.
As you can tell from our little projection up here on the wall, our topic today is using the CALI tutorials or lessons at some time when we may be disagreeing with them. I want you to know how this originally started. It was a question from Ed Quintel at one point asking, can we keep these folks busy until it's time to get on the bus to go to the baseball game tonight? And so we decided to come up with something that might be a little bit different from what we've been talking about before, because most of the time we talk about all the good things that go on and why we should be using these materials, and I guess that's still the main theme, but we are looking at the other side because people will disagree. And so what we're going to do with you today is go through some of the things and hopefully get a discussion going with you. Go through some of the reasons as to why we might go ahead and use something even when we disagree with it. Now obviously the topic is broader than just with CALI materials, but since we're here with CALI, it's even more fun to do it with their materials. So let's go ahead and take a look at some of the reasons why we might go ahead, and we'll do an overview first and then get into some of the specifics after that. One of the first reasons for doing it is perhaps we want to take a look at some new material before it's reached in class. That's one of the things that I do, and Deb and I were talking earlier today, and in my property syllabus I have hyperlinks that go right into the CALI lessons. And why would I do that for the students? Well, I want them to see the material in addition to what they are reading as far as casebook assignments are concerned, so they get a broader picture of what's going on and a more diverse approach to what is going on, because I think that from my perspective, I think that that generally works better for them. Another one of the ideas is to go ahead and get to reinforce material that's already been presented in there. In that sense, what I've done with the students is I've given them an extra credit project, and they will go back and complete these CALI tutorials and get at least 75% correct in all of their answers, and they give me the little certificate that CALI so nicely produces, CALI Author so nicely produces for everybody. Then they get an extra credit at the end. And this is the first time that I've used it, and just to let you know, it must have worked because out of 49 students, 47 of them did it. And they did them all. And I had 27 or 29 on the syllabus through all the different property lessons that are there. And the only thing they don't realize is, of course, by doing that, they destroyed their own curve, because with 47 of them having done it and all gotten the 75% out of it, it just made it even for everybody, but that's okay. And then, some other points that we have in here is you can provide additional detail to already what you've covered in class, which is a nice idea, because we obviously never have enough time to do everything. Alternative learning styles, that's one of the big points as to why we're here today and why we might think about doing CALI materials, because people learn differently. And we'll be looking at that approach a little bit later with some of the CALI lessons.
And let me interrupt you there just a second while we're going through these. One of the things that I think a lot of us that have written these lessons understood is while we were writing them, you sort of go through the process of, am I writing this as a new lesson for students who haven't seen the material? Am I writing this as a review lesson for students who have already had the material? So the author frequently thinks about those kinds of issues while they're doing them. So the lessons really have a lot of purposes. They're not just sort of single-purpose lessons. I think I've found that a lot of times my students think the only purpose in a CALI lesson is to review right before the exam, and that may not be the best use of them. So the lessons have a lot of purposes as you go all the way through them. So these additional purposes or uses that you see, each lesson may actually blend these purposes together. And as we go through the discussion today, there's a few examples that I've put into the PowerPoint where I want to point out that the lessons actually solve 2 or 3 problems for you. Some of them are sort of a very obvious surface level of teaching material. Some of them also then have sort of a secondary level of supporting some skills learning that you try to teach all the way through your class, and the lessons actually kind of help you do that as you go along.
Another point, obviously, is that there may be different ways of looking at the law. Particularly today, if you take a look at something in a property area regarding servitudes, you have the third restatement that's taking a different approach from what we've done traditionally. It gives the students a bit of a different perspective from the traditional hornbook and casebook approach that's there. Also, providing a higher level of involvement in the learning process than is possible in a class. They can go through this as often as they want. They get the feedback, they go through, they rework it. Sometimes we force them to rework it the way we style the lessons. We don't let them just answer and move on whether they've gotten it correct or whether they've gotten it wrong. The point is that you're trying to do more things even outside of the class. And even if you disagree with perhaps the content that might be there, as long as you know what's there, you have that opportunity to say, yes, I understand that there's this particular viewpoint, and this is the way that I approach that. And you give them then a little bit more of a feedback. Now, the negative to that is some students are goal-oriented. They'll simply say he or she wants, and then that's it, and that's all they'll do. So hopefully we'll be able to develop some kind of a dialogue out there where they'll be able to entertain more than just one line of reasoning. And then also, one of the advantages is the rapidity with which they are able to get a feedback from the CALI materials and the broader approach that we can take with these. And certainly not all of these will be exactly what you want, but hopefully what they do is they provide enough reasons for you to reconsider a particular approach that's been taken by one of the lessons, and find that there are other benefits that make it worthwhile, even if the student just isn't learning it exactly the way you would want them to learn it, or the way it makes sense to you. One of the things that I found in starting to write the lessons is that I had to rethink some of my approaches because I knew what made sense to me, but then looking at it for the student whom I targeted with my lessons, I had to stop to think about what was the best way for them to be learning with that, and make some judgment calls as I went through, as far as that was concerned. And then also, we know that there's never enough time to cover everything, and so even if they are not doing it exactly the way you would want it, at least they're getting points that you never would have gotten to in class, and they're not likely to be necessarily reading in a hornbook either, because the more traditional approach might have been taken.
Well, and that point, I think, is, you just mentioned the more traditional hornbook. I think the thing that faculty members sometimes forget is students are going to be using sources other than the ones you recommend. They will be using things other than the casebook. The good thing about the CALI lessons is these were written by other faculty members. They were read, edited by other faculty members. There's peer review going on. These things are edited and vetted through a series of different faculty members to make sure that they are valid lessons. They are not just something that the students are going to go to the bookstore and pay a fortune for, and you don't even know what they're getting. So as you're trying to look at these possible uses, where you're filling in detail, filling in gaps, adding some additional material, you're able to do it with material that you can have some confidence in, rather than some of the things out there that are for sale that you start trying to recommend your students not using. So I think that's an added benefit too, as you think about some of these ideas we have.
And Rod's point about them the other materials being for sale, I think, shouldn't be underestimated, because students, particularly 1Ls, want to rush out and buy a fortune worth of material. And as we know, a big problem for our students now is getting too deeply into debt. And here are CALI materials that are available to them without cost because they're provided by the law schools. And that savings to them is a tremendous plus, particularly in the long run in law school.
They're good points. One of the things that we have to remember is the students have so much available to them. And I had a very interesting reaction at the end of this semester, this last winter term. That's a euphemism in Florida, by the way. We really don't have winter, but they like to call it winter term down there. And the students at the end appreciated gratitude for a number of things, one of which the semester was over. The other that they really said that they appreciated was the involvement with the CALI lessons and the diversity of approach. And a number of them had commented that they weren't necessarily understanding it, whether they were reading it out of a hornbook or the casebook, and certainly they never understand it from class. And so they needed another opportunity to learn the material, and it was amazing how many of them said, I got it a different way. Whoever the author was on one or two of the lessons would approach it in a different way, and it made sense to them. And so I had to ask the ultimate question, did it make more sense to you when we went back in class? And they probably lied, but they said yes. to make me feel better after all of that. But really, it was interesting to see. I think they were giving pretty much honest answers out of that. And I certainly did appreciate, their willingness to express that. And I thought that that was a pretty positive result considering all the torture that I put them through. One of the bigger points that we were covering here is we have material that we're not necessarily agreeing to or agreeing with, and the lesson isn't exactly what we need, but is it possible that it can be useful to us? And I found, there's more than one obviously, but here with the landlord-tenant, Jim Smith takes an approach that's a bit different from the one that I do with landlord-tenant, and when he gets into delivery of possession, he gets into the covenants regarding the title of the property. And for me, I like it, even though I wouldn't teach landlord-tenant that way, I like it that he has it in there because he is reinforcing the other material that I do with title covenants in other sections of the property course. And so I think that it's a different approach. It is useful. It's not the way that I do it, but the students found that it was reinforcing for them. And so they liked that approach, that they were able to see it applied to other materials other than just the way that we were doing it and the way that the typical casebook might go ahead and do that. So we have some other possible uses that we have here, or that we might have, to add some detail to what we've already covered, to go ahead and provide additional material that we're not going to cover at all, and then change a lesson that we don't like, and then use it for your class. We're going to try to help you work, pay more attention and work a little more specifically with this. Let's take a look at the first topic that we have here, where there's not enough time to do additional examples. And Ronnie said, "CALI to the rescue." So let's see what he means. Go ahead.
Yeah, this, by the way, is just a screen capture off of the website at CALI, and if you're not familiar with using CALI, you can go to the CALI site, you can bring up the lessons, and you can just look down the list of lessons that are available in your area and read a little description. And I pulled this little description up because intentional torts is a subject in the first year course, right in the first semester. And it's a little easier than some of the other material, but there is a level of complexity to it that students don't quite get. And what I liked about, for example, these two lessons that Doug McFarland wrote is it gives the students, when they begin to work through multiple examples of the simple tort of battery, they start developing a certain sophistication to the understanding of tort law. And I just made that sentence up because I always wanted to use the word sophistication and tort in the same sentence. And it gives them a real sophistication on the details of that tort. And at the same time, kind of that skill that I said that they're learning just below the surface is a legal method, how to think like a lawyer. You've got the first semester student very early in tort law working through the details with multiple examples and at the same time applying law and fact. So you've got several things going on at the same time. Now, no one is willing to allow me to have like 15 to 18 hours to teach tort law, which is, I think, at a minimum. So I can use these sorts of things to give them all of that additional work with multiple examples. And so I think this sort of, these two lessons are very good examples of how you can use it to fill in detail.
Sure.
And the next example I put is two on cause and fact. Now, those two, obviously at a higher level of complexity, but if most of you will think back to when you studied tort law, when you studied cause and fact, probably all you remember is something about sine qua non, and you're not real certain what that was about, because you immediately went on to proximate cause, and you talked about Helen Palsgraf and Wagon Mound and all those sorts of things. Well, cause and fact is really a complex problem, and products liability has made it even more complex. And so here are two more lessons where, as a student is sort of caught in the press of time trying to learn materials, you can cover cause and fact and ask them then to do much more work to get the details. And these kinds of lessons are available in all the subjects to really give those additional examples that you just don't have time to cover in class.
Well, one point to make is the importance of doing those examples far outweighs whether the examples turn out to be done exactly as you would have done them. If you're going to make a trade-off between that's not exactly the way I would have done it and giving them that much more practice, it's sort of like working with a teaching assistant. The teaching assistant may not get it exactly right the way you would have done, but it's worth having the teaching assistant working with them. Well, now at least we know the teaching assistants are reputable authority, and what they've done has been vetted, so we don't have to worry about whether they're going to get it right or wrong. But even if it's not what we would have done, it's so much more important for them to have gone through it with this electronic teaching assistant than not to have done it at all.
One of the other advantages that we have by doing this is to go ahead and introduce different ways of looking at the same material. And again, this is with the idea that different people will learn in different ways.
And I pulled this one off too. If you are familiar with products liability, you know we had 402A of the second restatement that now has sort of morphed into the third restatement, and there is law and economics theories. What do we do with design defects? I mean, there are so many different justifications and rationalizations. I teach a course on products liability where we spend, a 3-hour semester course. Obviously, I don't have that kind of time in a basic torts class, but my students need to be exposed to that because that's what's really going on in the law today. So these kinds of lessons, I can cover basic concepts in the class and then introduce them to a lot of different and at times conflicting ideas that they might not otherwise see. Click. And this one is one I pulled. This is out of a lesson that I wrote on the right of privacy. And what it does is this makes a reference to the Brandeis Law Review article that was written back in the 1890s. And my ideal with that is trying to introduce the students to not only what is tort law doing, but an attempt to push them back into some of the classical literature of tort law. And so I'm doing things that maybe not looking at a completely different way of looking at the law, but different sources, things that they're not familiar with. And what I did with this one, by the way, if you're in the website, you can actually click on the little speaker button down there, and I read a little portion out of the Law Review article. And for many people, there is quite a shocking thing to hear the words of Justice Brandeis read with a Southern accent. It's quite a thing to hear. But this is a way to try to generate some interest in the classical literature of the law. And I think these are the kinds of things that CALI can help you do with modern technology.
Also, as law professors, we're trying to introduce our students to the culture of law. So Ron's point of showing Justice Brandeis is to illustrate what a snappy dresser looks like as a lawyer. And even though this is not what we would have picked, this certainly is a step up from the way they probably look in class.
One of the other items comes up in a property lesson. This one here under the common law rule against perpetuities. The person who drafted that is a certified maniac for putting this kind of lesson together. Uh-oh. It won't go to the web. Okay.
See, even the web
rejects the lesson. And putting this together, what was kind of interesting with it was a judgment call that had to be made. Earlier in the day, Deb had mentioned that the lessons that I had drafted, of course, I agree with them. And I said, no, after 2 or so years of doing these, I might change some of these and do a bit of a different approach with what's here. Putting this one together required that I step back and I think a bit more from, again, the student's perspective and an attempt not to be the same. One of the things that I was really thinking about, having gone through, I can't tell you how many case books that were out there and how many horn books and other supplemental materials, and just going, God, they're crazy. But in any event, knowing that this is an area that we do have to cover, it is expected and certainly needed. I know there were people who have opined at some point that the Uniform Statutory Rule against Perpetuities has done away with all that. I'm here to tell you that it hasn't. It certainly has made life somewhat simpler for us, but still there are points to consider. And one of the best ways to satisfy the Uniform Statutory Rule is to satisfy the Common Law Rule. So we might as well take a look at the Common Law Rule. And so what I want to be able to do with them is at least give them some opportunity to put together a logical approach, which I thought was a fairly decent thing to do. In this lesson, the first thing that we do in the introduction is to take a look at the total picture. The analysis, how do you go into all of this? Where do you go in working through the analysis? Because almost universally, when something comes up regarding a future interest, the compulsion, whether it's the professor or the student, is to get to whether this is valid under the rule against perpetuities when you're in that part of the book. Well, it seems to me that it would send the wrong signal to someone who's going to leave my property class and perhaps never see another property subject come up until maybe they go out to practice law and find out that torts isn't all that it's going to be, and maybe they need to do something more to earn more money out there while they're generating their tort clientele. And often they fall back on real estate because, as they all know, secretaries could go ahead and do the work, which I tell them is fine because then we cover them in their malpractice suits and we make more money in the litigation end. But the reality of it is they need some logical approach. And the very first question is, do you even have an interest to which the rule applies? And so there's a chart that's developed in this common law rule, or in this lesson on the common law rule, and it's a basic chart of questions. And it starts with the logical position, do we have an interest to which the rule applies, and then works its way all the way through until we get to the end that if in fact we do have an interest to which the rule applies, and if in fact it has gone ahead and violated the rule, then what do you do with it? Okay? And it's nice to see the reaction that I get from the students to the overall chart. The mistake that I find in having drafted the lesson is it takes, only 1 or 2 weeks to cover it because of how much material you have to go through to do this. And now, do I assign it? Yes, I do. But I assign it to them with a caveat, again, explaining to them why the maniacal author put it together the way that he did, and that there's a benefit to this, because, and the real benefit is that you do get to see the whole picture, and that was the reason. I know Deb and I had discussed it on the phone a number of times as I was putting it together, and trying to decide. I really went around on what I thought was the best approach, and at the time I thought the big picture was the best approach. Looking at their dear little faces, now they've gone through it for a while, I will probably want to break this down and provide something like this as a backdrop, that if they would like to see the total picture, that it's there. But nevertheless, it might work in a more manageable set for them if they were able to do more discrete lessons in the area. Although this lesson does say to them that once you do get to the point where you're screaming and banging your head against the wall, you might want to step out and come back to another section at another time. It doesn't have to be completed all at one time. But this is one where it has a lot of use and a lot of good points to it. It has taken a very difficult subject and probably made it even more difficult. But it is useful because they do get to see the big picture that's out of that.
Okay, one other thing is Joe and I teach things like the rule against perpetuities and future interest. Now, future interest is always a favorite of every law student. I'm sure you all recall that. And what surprised me when I started teaching it was people would come and say, what should I read? And I'd suggest something, and they'd come back and say, that sucks. How could you have said that? And then, so I say, okay, well, read this. And they go, well, that was better. And then they come back and they'd say, well, the third thing was better. I think I've got the fourth thing. Whatever the fourth thing was, that was brilliant. Why didn't I tell them that first? But my experience was it wasn't whatever the fourth thing was, it was that it was fourth. And so the more difficult something is, the more different perspectives you need to get the three-dimensional picture. And if what we were to do is assign them, keep giving them the same things that give them the same perspective over and over, that wouldn't help them. What we need to do is give them things that are a different perspective to give them that picture. And if the CALI lesson starts them off with a good interactive introduction rather than a deadening horn book, that gets them started a lot faster. But it gets them started even faster if it's not the approach I would use. Rather, it's approach something totally different so that they get, oh, you didn't mention this. Well, I did, but you didn't get it the way I said it. Good. It's a different perspective really helps. And not everything can be as fun as future interest. They have to take torts, unfortunately. But even in torts, it would be worthwhile.
Good.
Yeah, and it is. I've noticed, for example, in teaching the subject of proximate cause, which is what most tort students have the most trouble with, as a complex subject, frequently you have to teach it 2 or 3 different ways. I mean, you give them 2 or 3 different perspectives, and you get part of the class on each one, and then you're sort of stuck saying, well, if you got one of them, forget the other 2, because I was telling you the same thing. And you can do that with CALI lessons. You give them your perspective, you look in your subject matter, and you find lessons that cover the same topic, but maybe come at it from a different angle. And, some of the students will understand it one way, some will understand it the other. And ultimately, you may be right on the complex material. It doesn't matter what you told them. It's kind of the third or fourth explanation that finally makes sense because they're finally getting it. And so it is helpful in those complex areas to have several different perspectives.
And it seems to be one of the things that we have to realize is that, ultimately they're going to practice law. But they will be out there and they will be on their own. And somebody who will be in a transactional matter with them or in some litigation matter with them is going to take a different approach. And I think it's important that we let them understand early that there are differences that are out there. And yes, in fact, part of their obligation as becoming a professional is to think of these things in ways that, one, will make sense to them, but also they can present in a logical fashion to somebody else so they'll understand it. And that's the power of persuasion, I think, often when we get it, when we're able to do that. So I think it's really important that we're able to take these things, and even if we disagree with them, just go ahead and use them. And as I say, I'll continue to use this lesson, and I'll change it later. Again, some more benefits to dealing with materials that might be different. Just get into materials that you wouldn't ordinarily cover. I like to have a broader scope of background for them. There are things that it seems to me, from my old education days in a master's program, where they presented to us the thought, the more the person has a broad background in an area, the more they understand the more difficult concepts. They have something to which they can relate. And so by providing these background areas, it seems to help them even as we move on to some other areas.
Yeah, this is one. Tort law is an area of the law that's fought out in a trial court. It's where it actually occurs. And understanding the role of a jury and the role of the judge and the relationship between questions of law and questions of fact, it's hard to teach that. You don't. If you teach torts, you rarely teach that as a very distinct, concise piece of material. Instead, that's actually what you teach the whole time you're covering the course. So you don't really cover it as a separate topic, but you expect the students to understand it. So this is a topic that they can begin to see how they work through it. It's a topic you don't actually cover as a separate topic. Instead, you can let them cover it, and then they can see how it works throughout the whole material. And then there's those topics. I wonder if anybody covers this other than me, and that's strict liability in animals. And I wrote this, and I know, for example, in one of the basic torts case books, the Prosser case books, there's like a page and a half of text on it. You kind of read it and go on. And that's on the assumption, I guess, that no one does this anymore. Well, I like to think, I'm sure that most people at Louisville do, that all of our students from the University of Louisville will practice law in Louisville or Lexington or up in Cincinnati, and they'll all do securities work. But I happen to know that some of my students moved to Rooster Run, Kentucky, and represent rural clients who have cows and horses and pigs, and these things break down fences and move to other farms. And this is an area of the law that they practice. So here's a subject they can deal with. I happen to also know that strict liability with animals is one of the old traditional areas of the law. It explains strict liability, and in the same way I've talked about several times, it lets me show them some rules, which students love, black letter rules, while I sort of sneak in a little legal reasoning, legal thinking, and jurisprudence. If you can sneak that stuff in, they'll actually learn it. So not only do they learn some very traditional rules, which they like, they also have another example of looking at very traditional theories of law. So you can take something that is a subject you wouldn't have really covered because you don't have enough time, and whatever course you teach, you are convinced you need just two more course outputs to actually cover it. CALI lets you need 4 more. CALI lets you pick up some of those topics you just wish you had the time to cover. This is another good example of owners and occupiers of land. In the area of tort law, this is another old, traditional, sort of rigid area of the law, although there's some changes going on. It's an area some people either skip or go over so quickly that they don't really cover it. But yet it's another example where students can learn some of the law. It's an area that some of those students, as young attorneys going out, will wind up handling because it's the sort of thing that a young attorney might get. It's also on the bar exam, but also, again, it allows them to work through legal reasoning, thinking like a lawyer, applying law to facts, and doing a lot of those sorts of things that we'd really like them to learn how to do.
This is a lesson that was recently drafted, and one of the comments that had been made about it is, we just don't teach that way. And I understand that. As a matter of fact, one of the objections I tend to have about what we do in property is we don't deal with this particular subject. We seem to teach first-year courses and the like as if they were all litigation courses. And so when you get to a section on covenants, predominantly you're into issues as to whether we can enforce these covenants against A or B or C, whoever else might be out there. Well, the reality of it is that even if you are in a litigation setting, before you get to the question of whether we could enforce this covenant against somebody, we have to find out whether it was ever really created. And that is not a great part of what we find in our case books. But again, from a logical progression standpoint, I like to have a student understand that that's where you begin. So I don't have to teach it that way, but I can have it as part of the outside reading. It's a relatively brief lesson that is there, and they can understand where these items will come from, whether they're real covenants or equitable servitudes, or we call them restrictions, or whatever it might be. They get to see that. Also, there's a part of me that says, Joe, you used to be a transactional attorney for the most part, and your litigation was about a third of your practice, and you used to represent people who created these things. And then I come to law school and I find from Joe Harbaugh that statistics show us, and he's always quoting statistics that I can never find, but I like the idea that he quotes statistics, that 2/3 of attorneys generally are transactional attorneys. And only a third of them really end up as litigators, and we only know that maybe 5% of those cases ever get litigated. So when we look at litigation, it kind of dwindles in our perspective, and I would like the students to understand that yes, in fact, when you are out there in the real world, there is a point that you need to address when you're working with developers and associations and the like, and we do have to create these things. And so it gives them the opportunity to take that look at it, and I understand why you might not want to include this as part of your lesson package in teaching property, because there are so many other things to cover, like future interest, and it's more fun. And you want to go through and deal with the issues that are more important to you. But this is a nice piece of outside reading that the students can go to, even if you would never really do it in class. And it just gives them that opportunity to go ahead and do that.
One point of this, if you could go back for a second.
I'm sorry. You want me to show that I can actually do this?
Joe and I both teach both property and contracts. And in our curriculum, contracts comes first, and then property second semester. Now, there are very few other people who teach that combination of courses in that order. And that gives us a different experience with the students. Now, when we do contracts, a big part of the contracts course is creation of the contracts. But when people teach property based on the current property books, when they do covenants, they go right to covenants running with the land. And the only question is whether successors, either to the benefit or the burden, can enforce or have it enforced against them. And they skip right past the creation. So as contracts teachers, it strikes us how they miss the creation part, and that confuses the students. So, and of course, we point that out to the students, and they admit it, and they immediately refuse to admit they know anything about contract creation or that they've had contracts, and they're not so willing to admit they've ever been to college or high school. We have to beat that out of them. But that perspective is where we discovered the need for this lesson, which has proved to be, I think, accurate. That's why we included it, and that's why giving the students a lesson that you may not see the point to right away may reveal to you that they find that there's a need for it, and you can learn from it. The other thing is this is a product of that we co-authored, and I did a quick count before we came here. This is the 30th item that Joe and I have written together over the years. And never when we've started have I discovered either of us goes to the other with a draft, because it depends on the project who does the first draft, and presents it to the other where the other goes, oh, that's absolutely right. Usually what the other person says is, why did you do that? And that's not the way I would have done it. And so the interaction, the back and forth process produces something from which we both learn in the process, and a product that neither one of us would have started out with and probably no other teacher, but the end product, I think, is much better for them. And I always get to the end and hope that the students will have learned as much from the product as I did.
This is another screen capture, and it's just out of the CALI website. And while we're talking about topics you can use, and maybe topics you weren't planning on covering, one of the things I wanted to mention, and sort of use this as a reminder, is I teach basically torts and evidence, but there are other lessons hidden away in other places that are also usable. And if you were to go to the CALI site, bring this up, start off with whatever area you teach in, you can find lessons there on it. But also in torts, for example, such topics as insurance or remedies will have lessons that will cover things that I might think my students ought to have some familiarity with before they finish a course in torts, but I don't want to spend the time on it. And CALI is starting with a fellowship in remedies this month, and I'm hoping they'll add even some more sort of tort-oriented remedies lessons. So I kind of use this as a way first, if you're not using CALI much at all, to see the general listing, but also to remind you that there's a lot of others there. Don't just click on your own subject matter. Think of related subject matters, because there are lessons hidden away in some of these others that were initially written with maybe that major topic in mind, but in all the places the courses overlap, there's a lot of subjects, especially things that you just don't quite have time to cover, but you wish that they got somewhere.
A good example of that is teaching both property and real estate finance. What you want the students to have is a background in equity, because so much of real estate and mortgage law comes out of equity, but there's no longer a good book about it. And what you'd have to do, what I find myself doing, is sending them, or did find myself doing, is sending them to read the encyclopedia, Amateur CJS, the introduction there. But now, although you wouldn't find it right away from the list, CALI has a good equity introduction. And it really does exactly what Ron says. You can say to them in class, you need more background in equity. Have I got a spot for you?
Along those lines with what Ron Eves was talking about earlier, one of the nice parts about these lessons, and again, even if you're disagreeing with them, they become useful for the students, you can take a lesson and download it to your laptop or your desktop, and you can modify it. You can make it fit the way you would like to have something work. You don't have to work just as it is on the web page or the CD-ROM from CALI. You can make modifications. You can take, if Ron Brown is talking about equity, and carry it over more into the property or the financing areas by some extra text and illustrations and questions and all that you have. This is different from a Hornbook approach where they just go out and it's this still product that is there. We've got the opportunity to make changes that are there and have the students, benefit as far as that's concerned. In line with that, the top lesson that's on here, the Uniform Statutory Rule Against Perpetuities, there are interesting comments about that lesson. Certainly people would like to have us cover it because that is the approach that many states are taking these days. About half the states are in some form of the Uniform Statutory Rule. What I did in putting it together, however, is since it dealt with a statute, I didn't want to send what I thought might be a misdirection to the students, so that when I had the pop-up, or when I had the pop-up in this lesson, it goes to the statutory material, and then, as all statutes do, it refers to other sections, or other sections explain some things that are in our pop-up, and I've created hyperlinks that are in the quote from the statute that automatically, presuming they click on it, that automatically takes them over to the explanations, the explanatory material that is there. The comment that was made is it's unfair to expect the students to go ahead and do that, and that's your judgment call. You may disagree with me. Quite frankly, I tell my students to do that, and it's fine with me that people will take another approach, but I really would like the idea that they would see that and know that they're expected to when they get out there and practice, that is what you will do, that you will not simply read Section 5 and that's it, and that's all there is to it. You may have to go to some other sections in order to understand some of what is in Section 5. And so this is one of those lessons where if you don't like that, and I understand why you don't. I mean, certainly it is different from what other people will do, especially with first-year students, and especially in those schools where property is taught as the first semester course. We happen to have the advantage where it is our second semester course, and I can tell, well, look, you're all settled now. You know what to do. You know everything. So now let's take it up a notch. They actually believe me. But nevertheless, I can tell them that that's one of the skills that they need to learn, and they will see that as they hit this lesson. I expect them to go through and do those kinds of things. But if you don't like it, it's relatively easy to remove the link. If you can take the lesson, disagree all that you want in terms of the way those links are put in there, but you remove them and that is fine, and the students still get the benefit. By the way, this method, the way this lesson was put together is consistent with the common law rule. This one has its own chart, but the same setup, the same types of questions that you had in the common law. The first one is, do we have an interest to which the statute applies? If the answer is no, forget about it, as my old neighborhood used to say. It's gone. You don't have to do any more analysis under that. It's over. Say, yes, thank you very much, I'm out of here. But again, the lesson doesn't let them stop at that, because then the fun would be gone, and the opportunity to torture them would be gone. But what it does is, again, they get to see this chart, and they can see opportunities where they can get out of the lesson, get out of the analysis, and understand what the effect is in getting answers to their questions, or drop down to the next question, because you have to still keep on moving on through. So it gives them that opportunity to go ahead and do that. And I think that it is beneficial to them, even if you end up disagreeing with it, that at least they get to see what is expected of them when they actually get out there and practice for real.
And so the point of we're trying to make with this little section of it is, if you've gone through some CALI lessons and you've thought about using them, but then there's that one little piece you don't like. You disagree with that answer, or you disagree with that explanation, or you don't like a particular hypothetical, you can take it out. Or you've got a particular hypothetical that you've liked, you've used it before, you know it works for what you want, you can add it in. If there's just something about it that bothers you, or something you think could be made better, these things are not in a situation where they can't be changed. You can actually deal with them a little bit. And what's good about that is you don't have to start from scratch. If there's a couple of the lessons you really like, you just wish you could twist them a little bit, well, that's great. You can take what we have already, and you can add your little fine points. The next...
Clarify, you're talking about adding it and posting it on your school's website.
Yeah, because you don't change what CALI has on its web, but you get the advantage of that. And following up on what Ron Eads is saying, get some of these analyses, and they're different from the analysis you would have given in the same fact pattern. You're seeing different things. Well, if the students have this assigned to them already before they come to class, and you know that it's there and you know that you disagree with it, what a great opportunity to put it up on the screen in class and say, let's take a look at this. What analysis would get you to this result? And are there other ways of looking at this? Are there points of law that weren't considered? Are there facts in here that seem to be overlooked? Suddenly we're down to Ron Eads' thinking process. What do lawyers do when they look at material? Because aren't we always asking them with whatever they read to critique it anyway? Don't accept it? You get a case that's there, and could the court have been wrong? Oh, wait a minute, I can't say that in this part of the country. In other parts of the country, the court could have been wrong. Right? But there's the possibility. Or did they get to, or if it's a court that's wrong, I always ask them, is there something that the attorneys didn't provide, like some point of law that got overlooked? You can do the same thing when you're dealing with the analysis that you don't like in one of these lessons. It seems to work fine. Go ahead, Ron.
I added this, to make the change,
You'd get more work.
You'll need a code, and you might need to ask a question or two. And the way you would do that is to contact Ms. Deb Quintel at CALI, and that's her email address. It's not that difficult, but you'll need a little technical assistance to do it, and you will need a code to be able to kind of break it open. So that slide with that email address is just there, so you'll have that information.
We're winding down. One of the final topics that we're dealing with is this concept of varied approaches reach more people, because we are different. And I'll give you a perfectly good example of personal experience in terms of difference. Going to this lesson on the contract for purchase and sale, as you can tell, my transactional background came in again in putting my class together. I do want them to understand that real estate transactions begin predominantly with contracts, and that there are points that we should cover. And in working my way through this lesson, and then there's another lesson that follows that on the remedies coming out of that contract and dealing with the merger doctrine, it's a very interesting thing that happened to me in putting this together. And it may not be the way you'd ever want to be teaching a property class if you're a property professor, especially if you're not in the transactional mode. But I've always been looking for what I call the hook for property. For all the years that I taught contracts, I always thought contracts was a nice streamlined process. You go to the startup. How do we begin this relationship? What is the court willing to accept as a relationship that will make us feel comfortable if we need to provide a remedy at the end? And then I work my way all the way through with them in that entire contract approach, and I come to the end as to remedies that are out there. Property's been a bit different. Whenever you look at the case books, whenever you look at the Horn books, it's a series of disjointed topics, some of which relate to one another, and you try to make the connections with them so the students will have some sort of an epiphany, hopefully before finals, and preferably before the bar if they don't do it by then, but hopefully they'll get some kind of carryover that goes with that. What I found relatively interesting in putting this together, this and the subsequent lessons dealing with the remedies in, is it started to make more sense to me if I taught my property class as a transactional class. And I did that this year for the first time. I've generally always given them a contract for purchase and sale. Standard form contract, something you can just get from almost any place. And I would give that to them in the beginning, and we would try to tie in the topics into the different sections of the contract. Some seemed to fit and some did not seem to fit. In this particular setup, when I went and put the lesson together, essentially it began with the question, must the contract be in writing, or can it be something that is an oral contract? And of course we have to address the statute of frauds. Well, what started to come together is as I paid more attention to the details for the statute of frauds, you would have your express terms and your implied terms, and the question would come up, what kinds of terms should be in there in order for this to be enforceable under the statute of frauds? Because it's supposed to be the essential terms. And we would get into those subjects, and then in contracts I differentiate between contracts in general and then contracts for a specific area. Well, property became the specific area. And so we went into what terms are generally expressed, and that it must be in some cases, and then what are the courts willing to put in as implied terms in this. And I found that by doing that, every single subject that I ever covered in property fit into this analysis. Future interests, I simply ask them the question. If you are buying property today, do you want 100% of the time, or do you want some? And of course, greedy little devils say they want it all. And so we start with, if we can divide the time, then how do you determine whom to get into the contract? Or if they're missing, do you even have a contract that the seller can perform on? And it carries us all the way through all the different topics. You can get into issues on lack of marketable title. Why? There could be some easements that are out there that you can't get rid of and the buyer wasn't willing to take subject to, and it was never expressed in the contract. We have all these opportunities that are there, and this is under this topic of things are different. People learn differently. I'm not saying teach it this way, by the way, but what I'm saying is even if you disagree with the approach that was taken, the students at the end of this semester, for the very first time, expressed to me by the end they had a big picture as to what was going on. Now their exams are a little different on that issue, but nevertheless, the point still was that they felt that they had a bigger picture, that they could tie in concepts, and it wasn't a series of litigation cases on all of this. It was actually a transactional matter, and we went from the beginning of how we're going to put this together all the way through how do we close it up, and it got us into financing and everything, and all those terms that are there. And then that's us.
And I think that, to bring it back, one of the uses that I think most students see of CALI is quickly trying to cram for their final exam. And if it doesn't absolutely match what you covered, then they're frustrated. When in fact, there are a lot of uses for CALI lessons, even when they don't agree with exactly what you covered. And I think that's what we were trying to sort of get across.
Absolutely. Quite frankly, I like the diversity. I get a big kick out of having different approaches taken to things, because I think that generates students' questions, especially in a situation like mine where I have them read or recommend to them that they do the CALI materials before they come to my class. And then they do raise more questions, and I'm impressed with some of the questions they come up with. They almost sound like lawyers. Go ahead.
I hate to cooperate again. I would like to appreciate your work. So, you made a suggestion of having students read, as I heard it, doing an exercise that you may not actually cover in class.
Right.
And I get to the problem of trying to make sure they cover the stuff that I actually want them to cover. Do you have any suggestions?
That's why I did my extra credit. That's exactly the reason why I wanted to give them a benefit for doing this. And they're goal-oriented people. They're lawyers, or they're lawyers wannabes. Of course they're goal-oriented. And so I sat there for a while thinking about it. There was a part of me that said, this is required and you will do it, and I will test you and I will do this and that. Well, you know, we've all been down that road. And I told them they would get the extra credit, and I said 75% was the minimum that I would accept on every single lesson that was on my syllabus. And they had to present the certificate, and it would be double-checked. And I'm here to tell you, out of 49 students, 47 did it. One of the two who didn't was somebody who dropped out, and why the other one didn't, beyond me.
Is that a good excuse?
But, but you know, I gave them a hook, is really, and I never did I anticipate that I'd have 47 out of 49.
And there's something about the psychology of it being an extra credit that they like. They're getting something extra instead of that you assign it and you're forcing them to do it, that then they hate it. And we'll leave that to the psychologists, but it really, and because the lessons print out a certificate, you can then just collect them. You don't have to grade them. You can have a secretary collect them and score them. It's wonderful.
I'll be up in just a second. I know you raised your hand, but to answer your question further on it, one of the things that I know what the lessons are, so I know what they should have read. What I made sure of, as we would cover material that related to it, even though I might not have covered that particular lesson, is I'd ask questions that would allow them to reflect on what they had read, to bring this background into the discussion, so that I didn't take the time necessarily to go through the complete lesson and the development of it, but they could see how knowing that now enabled them to go on to another step.
And it may free up some time in class because that takes the pressure off to cover everything. Now you can hit what you think is most important and most confusing.
Yeah, I think this is a really difficult issue for us, not just for CALI lessons, but for all kinds of extra material. The students have a finite amount of time of class, and we cannot, by the use of technology, expand the time that is available to them. And so we are necessarily making choices for them, or forcing them to make choices when we add more instead of substitute. And that's not to say that some students can't use more. I find that when I tell students there's a CALI lesson on this, sometimes I will use it in terms of, if you want to read more about it, well, I don't get 47 out of 49 reading more out, I get more like 2 out of 49. But for those 2, that's the additional challenge, that's the additional depth that makes the course worthwhile for you. You know, we can't always bring the course down to common denominator levels, so that, I think it has that benefit for the students that are looking for a little bit more. For the person who knows they're going to be doing, you know, the course runaways, to do the strict liability with animals. And so I'm never reluctant to suggest additional materials, even if only 2 or 3 use it, because that sets a little higher tone. But I think we do have to be very, very careful as we consider the opportunities that technology gives us to pile it on, because we have to be respectful of our students' time demands.
And that's a good point. That's the reason why I didn't want to make another requirement, because quite frankly, I do have them have a horn book also to get background. But I did tell them in the beginning that if they wanted to trade off, find a horn book that you like. It's in the library anyway. Our library has everything. And so then you have that opportunity to go, if you don't understand from what we're doing, you have the opportunity to go over and read the horn book, and that's not any money out of your pocket then, because obviously these are free.
But I think also with the CALI lessons, you get more bang for your buck as far as the time goes, because they do have that incentive, the certificate at the end, and the lessons are paced to get them through it at a reasonable time. You get a time estimate, so you know how much you're giving them, as opposed to, particularly 1Ls, they get to the bookstore, and so many of them come away with this huge pile of stuff they'll never be able to read if they stay in law school 12 years. And you know that's unrealistic, so I think as far as time management, it's much more productive to give them the CALI lesson.
Any more questions? We appreciate your time. Thank you very much.